1968 ခုနှစ်မြန်မာနိုင်ငံတရားစီရင်ထုံးစာမျက်နှာနံပါတ်9 Lieutenant Min Lwin Appellant vs the Union of Burma Respondent ဤစီရင်ထုံး audio book ကိုအထက်တန်းရှေ့နေဦးအောင်ခိုင်ဦးအထက်တန်းရှေ့နေဒေါ်ပြည့်ပြည့်ဖြိုးနှင့်တရားလွှတ်တော်ရှေ့နေဦးထိန်လင်းဦးတို့မိသားစုကစီစဉ်ဆောင်ရွက်ပြီးဒေါ်ယူပါစော်မင်းမှဖတ်ကြားခြင်းဖြစ်ပါသည် Court Martial Appeal Court Criminal Appeal before Dr. Mao Mao, C.J. Kho, Thon Tan and ဦးအောင်ကြီး J.J. Lieutenant Min Lwin Appellant vs the Union of Burma Respondent Suppression of Bribery and Corruption Act 1948 Section 4.1 Conviction under Read with Defense Service Act Section 71 Evidence recorded under Rule 22.3 Defense Service Rules whether a witness should be given due warning before giving evidence. The appellant was convicted under Section 4.1 of the Suppression of Bribery and Corruption Act 1948, read with Section 17.1 of the Defense Service Act. This evidence recorded under Rule 22.3 Defense Service Rules requires that the evidence of each witness should be read over to him after it has been recorded and signed in token of its correctness or attested. If the witness cannot write his name, the evidence is however not an oath, nor is it required by that rule that a witness should be given due warning before he gives his evidence. The warning and caution are clearly meant only for the accused before he makes his statement. When his turn comes after he has had all the evidence against him, it is only at the trial before a court-martial, if the case is sent up, that oath is administered to a witness as provided by Rule 139. The accused also is given a choice to give evidence on oath at the said trial as provided by this rule, after the court has explained to him the provisions of Rule 57.1. ဦးမြင့်စိုး for the appellant, ဒေါ်မြတ်သန်းနု government advocate for the respondent, ဦးအောင်ကြီး judge, the trial by summary general court-martial of Lieutenant Min Lwin, a commissioned officer of the Burma Navy, for an offense under Section 4.1 of the Suppression of Bribery and Corruption Act 1948, read with Section 71 of the Defense Service Act, resulted in a conviction for which he was captured and sentenced to 4-year rigorous imprisonment, as his conviction and sentence were confirmed by the Chief of Staff on 2nd March 1966. He has now come out on appeal. Before dealing with this appeal, it will be necessary to mention that number 87100 Sergeant Thong Shui, who had committed the same offense with Lieutenant Min Lwin, was also dismissed from the service and sentenced to 4-year rigorous imprisonment. His appeal to this court in Criminal Appeal number 10 of 1965 was summarily dismissed on 23 April 1965. The grounds of dismissal given in a short order were that Sergeant Thong Shui's own statement had been corroborated by those of Lieutenant Min Lwin and one Mr. Kiran Bo. The case against Sergeant Tong Shui, centered on 11 December 1964, was decided on the same day on his plea of guilty. This present case is, however, a separate trial and, in the same way as Lieutenant LWIN gave the principal evidence against Sergeant Tong Shui, the tables have turned for. In the trial of Lieutenant LWIN, Sergeant Tong Shui is the principal witness against him. According to the evidence of Sergeant Tong Shui, he and the appellant had known each other since 1961, and at the time of the occurrence of this case, Sergeant Tong Shui was serving under Lieutenant LWIN, while both of them were attached to the auxiliary MIS, ထောက်လှမ်းရေးအကူတပ် with its headquarters at number 199 Boundary Road, Rangoon. At the material time, which was in June 1963, quite a lot of illegal traffic in gold was being carried on by black marketeers in Morgan Street. One Indian by name Nagalenda, apparently a keen black market competitor, and who had befriended with Sergeant Tong Shui, gave him valuable information about another party. When this information was passed on to Lieutenant LWIN, he and some of his men raided number 52, Morgan Street, at about 5 p.m. on 18 June 1963. 8 gold bars were seized and some Indians arrested. One Major Teng Shui, plaintiff witness 8, was informed about this seizure. He was surprised because the only 2 persons who could order such a raid were Colonel LWIN, chief of MIS, and himself. Neither of them had ordered this seizure. The accused, therefore, one as to explain, submitted that he had made this raid and seizure while he was executing another piece of work. Major Teng Shui, however, ordered Lieutenant LWIN to hand over the case and the gold bars to the BSI, and at the same time, he informed U La Tang, plaintiff witness 5, director of the BSI, to expect and take over the investigation. But after the gold bars and the Indians had been handed over to the BSI, Major Teng Shui was personally informed by Lieutenant LWIN the next day that he, appellant, had received information that the BSI had accepted money in this gold case. This made Major Teng Shui take away the arrested Indians to his headquarters at Boundary Road. As soon as U La Tang knew about this, he offered to have his men lined for identification. But a middle course was chosen, and instead of lining up the MIS and BSI men, their photos were shown to the 3 Indians, one at the time, in the presence of U La Tang, Lieutenant LWIN, and Captain Wan Tun. Plaintiff witnesses, none of the 3 Indians could identify the alleged bribe taker. The arrested Indians were, however, kept in custody at Boundary Road, where Lieutenant LWIN and Sergeant Tong Shui were apparently in sole charge. The rich Indian by name Lakhna, eventually arrested, also came into their hands. On the day he was brought into custody, Lakhna requested to be taken to his house because, as an ailing man, he was in need of his medicine. The accused and Sergeant Tong Shui with some escort took him in a car to his house. Sergeant Tong Shui took the opportunity of introducing the brother-in-law of Lakhana to Lieutenant Min LWIN. After the medicine were collected, they returned to Boundary Road, and it was during the detention of this rich Indian Lakhana that Lieutenant Min LWIN and Sergeant Tong Shui conceived the idea of demanding a bribe for his release. One day, Sergeant Tong Shui took his boji, accused to insane, to enjoy with him the company of two ladies, both of whom were known to the sergeants. They found the ladies, took them to Rangoon, and after having a good time with them, saw them back to insane. This was not the first, but the second occasion that both the boji and his sergeant had in this way enjoyed together. They had thus become intimate friends, according to the accused, as stated in Exhibit 9. It was on the way back to Rangoon that Sergeant Tong Shui asked, "Benele boji, dine kalasi ka ngui taung me," and that he, accused, replied, "In Lobo." On their arrival at Boundary Road, the accused first refreshed himself with a bed, after which he ordered Sergeant Tong Shui to bring Lakhana, the rich Indian, to the meeting room for examination. The accused had already examined him before, but on this occasion, after a few preliminary questions, he asked Lakhana whether he would be willing to pay for his release. The Indian was perhaps surprised, for he was alleged to have answered that he did not think the boji would accept, but if he wanted the money, he was prepared to buy his liberty with it. Later, the accused also asked him if he would part with the ring he was wearing, and to this Lakhana replied that it was of little value. After these few questions, all in the presence and hearing of Sergeant Tong Shui, the accused took the sergeant aside to another place and told him to do the needful and to demand 30,000, after which he left the room. It is in Sergeant Tong Shui evidence that he demanded 30,000, but the Indian pleaded it was too much and requested that it be reduced to 25,000. The sergeant went down and informed his boji about it, saying that the Indian was prepared, but requested to be taken to his house for the money. The accused said that such a course would be dangerous, as they would be seen. He therefore told Sergeant Tong Shui to ask the Indian whether he could not talk to his house on phone. This was agreed upon, and the Indian was taken into the commanding officer room, where there was a phone. The accused told Sergeant Tong Shui that he, accused, would go down to the exchange room and listening to the conversation from there. When the Indian was talking to his house, which he insisted should be in Burmese, the message was to his brother-in-law, Mr. Kirambo, already referred to, and it was arranged that just a check bearing his Lakhana signature would be sent by the person to whom the money was to be delivered, and the place of meeting was also arranged. The accused and the sergeant lost no time for, after putting back the rich Indian into custody, they immediately set out in the Land Rover for the rendezvous, where the brother-in-law was soon spotted waiting on the platform at the junction of Mughal and Fraser Street. They immediately set out in the Land Rover for the rendezvous, where the brother-in-law was soon spotted waiting on the platform at the junction of Mughal and Fraser Street. The accused, however, took good care not to go to Kiranbol. The sergeant was to go with him to Nandita restaurant in a three-wheeler, for which the accused gave him the fare, and the accused arranged to follow up in his car and keep them within his sight. According to Sergeant Tong Shui, who was already known to Kiranbol, they went to Nandita restaurant, but when they arrived, they saw a military car. This made them separate company, but they met again when danger was past. They had a short conversation regarding the promise to effect the release of the Indians as early as possible. Kiranbol also begged that he be allowed to buy some meat and cakes from Shami restaurant to be taken by the sergeant and given to his brother-in-law, Lakhana. The money, which was brought in a packet, was then given to the sergeant, but the small sheet of paper bearing the rich Indian signature in English was merely shown to Kiranbol, but kept back by the sergeant as bidden by the accused, lest it created evidence against them. In the meantime, the accused waited patiently, but in great anxiety, because he had lost sight of Sergeant Tong Shui, and only when the sergeant returned, it was with a sigh of relief that he too had evaded the military car and had brought the money safely. The division of the bride was done within the compound of the naval base at Monkey Point, to which place they went as chosen by the accused because it was the safest. This division was practically even. The currency notes were in high denomination, and the sergeant received J 12,000, while the accused took the balance of J 13,000. The accused, according to Sergeant Tong Shui, made it clear that he, Tong Shui, was being treated fairly and to his satisfaction, and that being so, both vowed secrecy as nobody but just the two of them knew about this whole affair and the money they had obtained. Sergeant Tong Shui transfer to Mandalay had already been arranged some time back before this occurred, and it was within a few days after he had obtained his J 12,000 that he was transferred to Mandalay. The accused also, within a few months, was sent back to the Navy, to which he really belonged. It will appear that Sergeant Tong Shui did not have a clean record. Some allegation of bribery had been leveled against him during his absence, and to clear up these matters, he was sent for from Chao, to which place he had been sent from Mandalay. At the inquiry at Rangoon, Sergeant Tong Shui revealed not only the truth in the case he was then wanted, but also in this old case, which incriminated Lieutenant Min Lui. At that time, the accused was serving at Mumbai, and on 25 January 1964, he was summoned to report himself to the director of MIS, Major Teng Han, at the War Office, Rangoon. On his arrival there, on 27 January 1964, the accused was questioned about this court case. He denied all knowledge about the bribery, but he was nevertheless arrested as concerned in it. From the evidence given on oath by the accused, it appears he was suffering from various forms of illness, and for which he was kept at insane jail, where he received medical attention. Finally, he was sent back to his house on 31 March 1964. On 1st July 1964, the accused was summoned to come and give evidence at number 199 Boundary Road as per summons exhibit Nya, date the 29th June 1964. His statement was recorded in the summary of evidence by Captain Mu Ang, plaintiff witness 4. This summary of evidence was in connection with this very case against Sergeant Thong Shui. Lakhana, the rich Indian, had died about a month after his release. 3 witnesses, namely Private Jorway, Mr. Kirambo, and Lieutenant Min Lui, were examined, each in turn, and the accused, Sergeant Thong Shui, was given an opportunity to cross-examine each one of them. Sergeant Thong Shui cross-examined Mr. Kirambo and Lieutenant Min Lui. It may be noted here that evidence recorded under Rule 22(3) Defense Service Rules require that the evidence of each witness should be read over to him after it has been recorded and signed in token of its correctness or attested, if the witness cannot write his name. The evidence is, however, not on oath, nor is it required by that rule that a witness should be given due warning before he gives his evidence. The warning and caution are clearly meant only for the accused before he makes his statement. When his time comes after he has had all the evidence against him, it is only at the trial before a court-martial, if the case is sent up, that oath is administered to a witness as provided by Rule 139. The accused also is given a choice to give evidence on oath at the said trial as provided by this rule, after the court has explained to him the provisions of Rule 57(1). This had to be mentioned here because when Captain Mu Ang gave evidence, the defending officer raised an objection that Lieutenant Min Lui evidence, exhibit Nya, true copy, was inadmissible because Lieutenant Min Lui had not been given due warning. To revert to the summary of evidence in which the accused gave evidence against Sergeant Thong Shui, it is very clear that he not only gave a full statement against Sergeant Thong Shui, but when cross-examined, he answered every one of those 13 questions. Sergeant Thong Shui himself made a statement after the necessary warning had been given. Based on his admission and the evidence by the 2 principal witnesses, the court-martial convicted Sergeant Thong Shui without further examination of witnesses. the summary of evidence alone was sufficient, since Sergeant Tong Shui had pleaded guilty. 5. Rule 159.3. It was after inspection of this proceeding in original that this appellate court summarily dismissed Sergeant Tong Shui's appeal on 23 April 1965, as mentioned earlier in this order. In the present appeal, the case undoubtedly rests upon the evidence of accomplice Sergeant Tong Shui. The two exhibits Nga and Sa Lin, admitted on 23 July 1965, were also taken into consideration by the court, but neither exhibit Nga nor Sa Lin found in the proceedings are the originals. It is only the originals that are considered the best evidence. 5. Section 62 and 64 of the Evidence Act. The evidence signed by Lieutenant Min Lwin in token of its correctness should have been tendered, but as this has since been called for by this court, it is now before us. Exhibit Sa Lin, which is also not the original, need not be considered here because it is a statement by Sergeant Tong Shui against the accused during the summary of evidence. In the course of the trial against Lieutenant Min Lwin, contradictions, if any, were not proved by the defense to have exhibit Sa Lin found before the court in the same way as it is done in civil courts, where statements to the police are concerned. We will therefore confine ourselves only to the evidence given on oath at the trial by Sergeant Tong Shui. Regarding the accomplice evidence given by Sergeant Tong Shui, one valuable witness whom he mentioned could not be obtained to corroborate him. This Mr. Kirambo is not traceable in India, and as he was not subjected to any cross-examination by Lieutenant Min Lwin, the true copy of Mr. Kirambo's evidence in the summary of evidence against Sergeant Tong Shui was rightly rejected as inadmissible. The small sheet of paper on which Lucknow signed his name was handed over to Lieutenant Min Lwin, and Sergeant Tong Shui said that this paper was crushed in his hands. According to the accomplice Tong Shui, he said he received a letter from the accused about the release of the 4 Indians, and that all was well. But this letter, received at Mandalay, was also destroyed by Tong Shui himself. In an offense like this, where secrecy has naturally to be observed, and when only 2 persons know about it, the prosecution is correspondingly faced with a very difficult task of obtaining corroboration in material particulars. In this case, however, a few points do exist which can safely be regarded as corroboration in material particulars to render the accomplice evidence worthy of belief. Sergeant Gamyi, plaintiff witness 2, was in charge of the kingman who kept watch over the arrested Indian at 199 Boundary Road. His evidence is that he saw Sergeant Tong Shui and Lieutenant Min Lwin taking out and bringing back the Indian now and again, that this was done by nobody else except these two, that they never asked for a guard when these Indians were taken out for examination, that the Indians were taken out between 7 and 8 p.m. and that among them, he came to learn that one was a very rich man. Gamyin was recalled for further examination and he stated then that on 8 July 1963, the Indians were released as ordered by Lieutenant LWIN and that Sergeant p.9 brought the release order. From Sergeant Gamyin evidence, it is apparent that circumstantially only these two persons, Lieutenant LWIN and Sergeant Tong Shui, were doing the work of taking out the Indian without any escort. They thus had every opportunity to talk whatever they liked to this rich Indian and demand the money in question from him. Tong Shui alone, a mere sergeant, could not have inspired confidence that a release would be obtained at an early date without Lieutenant LWIN backing him. As the release was bought for a very large sum, Sergeant Gamyin corroborated the fact that it was at the instant of Lieutenant LWIN's order the release came at last. A parcel of Sergeant Tong Shui evidence will show that nobody had access to the Indian except him and Lieutenant LWIN, and this was supported by Sergeant Gamyin. Again, in Sergeant Tong Shui evidence, it is found that after money had been received, Lieutenant LWIN said, ဒီကိစ္စဟာငါတာဝန်ဖြစ်နေပြီကလားတွေလွတ်ရလွတ်ကြောင်းငါရေးရတော့တယ်ဟုဆို၍ကောက်ရေးပါသည်ဘာရေးတလဲမသိပါ Turning to the evidence of Major Teng Shui, his statement on this point is expressed in these words. ဖမ်းဆီးခဲ့သောကလားများကိုအချုပ်မှလွှတ်ရန်အတွက်ဗိုလ်ကြီးမင်းလွင်ကကျွန်တော်တို့ထံအစီရင်ခံပြီးမလွှတ်နိုင်ပါသည် This again therefore corroborates the accomplice Tong Shui on a very material particular, namely that he knew that Lieutenant LWIN, being under a great obligation, had to write to his superior officer and submit reasons to effect an early release of the Indians. Learned counsel for the appellant stressed a point that when the accused went to the exchange room, as alleged by Sergeant Tong Shui, to listen in to what the rich man would say on the phone, no independent witness was cited to prove this. Now, the MIS headquarters at Boundary Road could not be busy after the usual office hours, and an operator or operators were therefore not required for night duty. In Sergeant Tong Shui evidence, he clearly stated, ထိုအချိန်၌အော်တိုအိတ်ချင်းတွင်မည်သူတာဝန်ကျသည်ကိုမသိပါတာဝန်ကျသူ2ယောက်ရှိကြပါသည်မည်သူအလှည့်ဟုမသိပါထိုနေ့ညကရုံးခန်းထဲတွင်တာဝန်ကျအရာရှိသို့မဟုတ်အကြက်တဦးဦးကိုမတွေ့မိပါ But if there had been an operator on duty, it is most unlikely that the prosecution would have left out such a vital link in the chain of evidence. There are many rulings regarding an accomplice being unreliable unless corroborated in material particulars, but the case of Gafford and another Fast Emperor I may be cited and the relevant passage produced. As has often pointed out, it is not necessary that the story of an accomplice should be corroborated in every detail of the crime, nor is it necessary that the corroborative evidence should itself be enough for conviction. If that were so, the evidence of the accomplice would not be needed at all. Exhibit nga in the proceeding is only a true copy. We have, however, the original summary of evidence against Sergeant Tong Shui before us, though recorded on 2nd July 1964. The year was mistakenly written 1963, when the accused was cross-examined by Sergeant Tong Shui on certain points given in his evidence. The answer by the accused only strengthened the evidence of his admitted complicity in the crime. In answer 3, for example, he admitted he did not object to Sergeant Tong Shui's proposal to demand a bribe because he accused was eager for the money. ငွေမမောသဖြင့်မကန့်ကွက်ခဲ့ပါ At his trial, the court was fully aware of the gravity of the answer the accused had given to Sergeant Tong Shui, and the court therefore asked him about them. The accused replied that, with the exception of answer 1 and 2, the rest were untrue. Now, at the inquiry of Sergeant Tong Shui, the accused implicated himself and his partner in crime, but when his own trial came round, he tried to extricate himself by denying his previous statements. It appears to us that when an officer like him tries to suit himself according to the occasion, and is later found to contradict his previous statement, he can hardly be regarded as reliable. The allegation he made against various officers cannot be believed either in the absence of any foundation to show that his complaints are credible. We have given our reasons that the evidence of Sergeant Tong Shui, though an accomplice, has been corroborated on some material particulars to assure us that he has spoken the truth, and we have also shown that the accused, on the other hand, has proved himself to be unreliable. We would therefore hold that the conviction and sentence passed upon the accused by the court-martial need not interference and order that this appeal be dismissed.